What to know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Saturday, October 11th. I hope you guys are having a good weekend so far. I wanted to dive into this new motion to dismiss the indictment against Sheriff Mickey Stines, who was caught on camera shooting Judge Mullins in his chambers. This is a very interesting filing to me. I've been curious as to his state of mind leading up to the shooting. And we're kind of getting a glimpse of that in this filing. So let's jump right in. They cite prosecutor misconduct at the grand jury proceedings as their reason for dismissing this indictment. Specifically, the Commonwealth violated the defendant's constitutional rights and elicited false and misleading testimony which prejudiced the defendant and tainted the grand jury proceedings. The statement made by Detective Stamper that the defendant was in his sane mind is false and intentionally misleading and prejudicial to the defendant. An indictment returned by a legally constituted and unbiased grand jury, if valid on its face, is enough to call for a trial of charge on the merits. However, dismissal of an indictment by a trial court is appropriate if it's established that a violation substantially influenced the grand jury's decision to indict, or if there's grave doubt the decision to indict was free from the substantial influence of such violations. And in the footnotes, they're just citing cases that they're referring to. They go through a couple of cases where the grand jury indictment was dismissed due to prosecutors in those respective cases eliciting false testimony. In the case at bar, the Commonwealth elicited and Detective Clayton Stamper testified to multiple false statements before the grand jury. This testimony prejudiced Mr. Stines and resulted in an indictment. This case was presented to the grand jury approximately 2 months after the defendant's arrest and preliminary hearing. The Detective and Attorney General's office had ample opportunity to investigate and review evidence, including witness statements before presentation to the grand jury. After the Commonwealth concluded its examination, multiple grand jurors asked very specific questions of Detective Stamper, the answers to which clearly influenced the jurors' decision to indict. Had the Commonwealth presented truthful and accurate testimony to the grand jury, the outcome would have likely been different. On November 21, 2024, Kentucky State Police Detective Clayton Stamper testified before the Letcher County Grand Jury seeking a murder indictment against Sheriff Mickey Stines. Detective Stamper, the lead investigator in the case, is charged with the duty to have knowledge of his agency's investigation. Despite overwhelming evidence to the contrary, Detective Stamper and the Commonwealth put on testimony that the investigation showed defendant was in his sane mind. While the Commonwealth argues the defense is confused about the rules of civil procedure, defendant respectfully disagrees. Defendant does not submit to this court that the Commonwealth needed an expert to testify as to the mental health of the defendant. As stated in the recent status hearing, the defendant believes it is unwise to even allow the witness to go down that road, but they are free to do so. What the Commonwealth cannot do is mislead the grand jury. This is exactly what happened as a result of the reckless provision of information that is objectively untrue. Defendant will outline its basis for this claim, but seeks an evidentiary hearing to put on further evidence in support of its position if necessary. First, Detective Stamper was questioned about whether there was any type of hallucination, psychosis, depression, any mental health issues in the documentation from Dr. McDougall, who saw the defendant the day prior to the shooting at the urging of his family and coworkers. The Assistant Attorney General then hands Stamper and asked him to read a snippet of a record from Dr. Stein's visit to a medical provider the day before the shooting. However, the Commonwealth and its witness do not disclose the same records from the day before the shooting. His doctor diagnosed an acute stress reaction. In a little section here, it says a quick Wikipedia glance reveals the following. Acute stress reaction, or ASR, also known as psychological shock, mental shock, or simply shock, as well as an acute stress disorder, is a psychological response to a terrifying, traumatic, or surprising experience. The reactions may include, but are not limited to, intrusive thoughts or disassociation and reactivity symptoms such as avoidance or hyperarousal. It may be exhibited for days or weeks after the traumatic event. If the condition is not correctly addressed, it may develop into PTSD. Another juror asked, quote, "So, Dr. McDougall said there's pretty much no mental health issues, but was there any major physical health issues that he was struggling with that might have affected his mental health?" End quote. The witness answered, "No, not that I'm aware of." The grand jury asked for medical records. A snippet was read to them. They were told there was nothing of note in them. The diagnosis from this visit makes it evident that this is untrue. As in Baker, the witness and prosecutor are charged with the knowledge gained in the investigation. Second, the Commonwealth has represented that the first unrecorded meeting was for the purpose of obtaining grand jury subpoenas for Appalachia Regional Hospital records and Letcher County jail records. However, the Commonwealth's witness failed to note the mental health evaluations that were initiated by the government via a visit at the jail. These examinations were conducted at Kentucky River Community Care on September 20th, 23rd, and 24th of 2024. Those evaluations included observations of active psychosis. He had been given Risperdal and Seroquel by the jail prior to the exams as noted in the medical record. The same notes indicated that Mr. Stines had been seeing his primary care physician for stress and anxiety. This is the same doctor referenced in the grand jury transcript. Follow-up notes from the mental health evaluator indicate that his condition improved after the administration of the medications. The Commonwealth has stated that one of the purposes of the unrecorded grand jury hearing was to get subpoenas for mental health records and jail records. In fact, the only evidence given from that first grand jury meeting was a note saying the grand jury sought all medical records, including, but not limited to, mental health records and pharmacy records for Sean Stines from June 19th, 2024 to present. We also request any and all records from the detention center. It appears clear that the mental health evaluation on September 23rd and 24th fall within the requested documents. These two evaluations were done while Stines was at the Leslie County Detention Center. Yet the discovery provided detailing the exhibits given to the grand jury curiously do not include any records from the jail. They go on to say the Commonwealth chose to ignore a records request from the grand jury for mental health and jail records from June 2024 to present, which was supposed to be the only purpose of the unrecorded meeting. The Commonwealth then allowed their witness to state the investigation did not reveal any evidence of a mental health issue, despite Dr. McDougall noting an acute stress reaction the day prior to the shooting and mental health providers working with the jail describing an active psychosis and the jail prescribing medications. He failed to comply, or at best selectively comply, with the grand jury's request for subpoenas, coupled with the prosecutor allowing the detective to make such a recklessly false statement falls well within what Baker describes as misconduct at the grand jury stage. The grand jury requested all mental health records from June 19th, 2024 through present. They also requested all the files from the Leslie County Jail. The jail referred Mr. Stines for the mental health evaluations. The jail administered the psychological medications in conjunction with the evaluations. The Commonwealth's failure to provide or mention these records is in direct violation of the request by the grand jury, and thus is in direct violation of the Baker mandate that prosecutors maintain the independence of the grand jury investigation. They go on to say the Commonwealth was not free to cherry-pick what items the grand jury got to hear about given the specific requests, and both requests for mental health records and jail records, which would encompass the detention evaluations he had. The failure to produce them alone is misleading. Adding this with allowing the detective to state there was no evidence of a mental health condition is misconduct. The evidence of psychosis was within the records the grand jury sought. Defendant concedes there was no requirement to put this in evidence absent the grand jury's request. However, there were two requests that were blatantly ignored and specific questions that were answered falsely. The detective and prosecutor in Baker were obviously underprepared for the grand jury, and both were relying on work done by others. However, the recklessly misleading information prejudiced the defendant in Baker, and the facts in the case are significant and more prejudicial. Additionally, the Kentucky State Police, under direction of lead investigator Stamper, conducted multiple interviews. This is what's interesting to me, is to hear from people that knew Sheriff Stines and saw that something wasn't right leading up to the shooting. Practically all the interviews call into question the defendant's mental status in the week preceding the shooting. On September 20th, 2024, Kentucky State Police interviewed attorney Daniel Dotson. Dotson said he had told defendant to seek a mental health evaluation prior to the shooting, and the defendant told him he was going to see his family doctor. Dotson said defendant never threatened him or Judge Mullins, but that he was so concerned about Mickey's demeanor that he contacted the Kentucky Bar Association to determine what action he could take. Dotson told the Kentucky State Police that he spoke to Kevin Mullins and told him Mickey was, quote, losing it and could not take this kind of pressure, in reference to the civil suit involving, quote, some crack whore wanting money, end quote. Dotson goes on to tell Kentucky State Police that he spent hours researching it and Mickey had, quote, paranoid schizophrenia, end quote. Dotson said that Mickey was criminally insane. Dotson said that Whitesburg Police Chief Tyrone Fields told Dotson that on Wednesday night, the night prior to the shooting, that Mickey had called him. And when he got off the phone, he told his wife, quote, that son of a bitch has lost his mind, end quote, in reference to the defendant. This was based upon the paranoid thoughts defendant had disclosed. Chief Fields was interviewed by the Kentucky State Police directly. Hill stated defendant's demeanor had changed and there was chatter that Mickey was unwell or off his rocker. He states that he was looking for Mickey to discuss his mental health and refer him to help that is available. Christine Bowling of the Letcher County Sheriff's Office staff told Kentucky State Police the staff had stated they were concerned about Mickey due to his very strange behavior. Specifically, the day prior to the shooting, Sheriff Stines told her that Daniel Dotson had told him to give him money and kill himself or they were going to kill his wife and daughter. Bowling states the sheriff insisted on going to his home to check on his family and made her get his bulletproof vest on and have someone call and check on his wife. This is confirmed by Ring video footage provided in reciprocal discovery. Bowling states that she and other staff took the sheriff to Dr. McDougal based on the strange behavior. Bowling stated that during the food delivery he attended with Michael Clark, the recipients were acting strangely and were wanting him to take the food up on a hill on a side-by-side. This corroborates what Clark told Kentucky State Police. The Kentucky State Police detective testified that a witness who was with Mr. Stines immediately prior to the incident did not notice anything peculiar. Detective Stamper testified Mr. Stines was with Michael Watts making a food delivery immediately prior to the incident. This statement, in and of itself, was false, as interviews show that Mr. Stines delivered food with Michael Clark, not Michael Watts. Michael Clark, who was very close with Stines, was interviewed with Kentucky State Police immediately following the incident and noticed Stines had been off and distant, like something was bothering him and his mind was elsewhere. LaShawna Frazier, staff at the sheriff's office, told Kentucky State Police she had asked Dr. McDougal to move up the sheriff's upcoming doctor's appointment because she was very worried about him. She went with Bowling and the sheriff's family to check defendant into the doctor. Frazier stated that en route to the doctor, the sheriff stopped by his wife's office to check on her. Frazier stated the sheriff was encouraged to go to the doctor because he had some kind of psychosis going on. In response, the Kentucky State Police echoed back, stress. Frazier responds, anxiety. And I think that he, between the weight loss, the non-sleep, I think his anxiety was completely off the charts. I do feel like he was in a psychosis. Sherry Stines, the defendant's aunt, told Kentucky State Police Detective Anthony Trotter that Mickey was concerned that someone was on the back street near where he lived watching his house. She stated he did not act like himself. The Kentucky State Police interviewer talking with Sherry Stines stated that he had known Mickey and attended high school with him. Detective Trotter opined that Mickey was definitely not acting normal. Sherry told Trotter that the sheriff wanted his aunt to check on his family because he observed someone walking on the street. She stated he seemed really freaked out and stated he could not sleep. In a follow-up phone call with Trotter, Sherry Stines called and informed Trotter that Mickey had called her on the day of the shooting and asked about where his grandmother, nicknamed Bones, was that day. Bones had been dead for 3 years at the time of that call. Kentucky State Police body camera video from multiple officers on scene very clearly shows Mr. Stein's paranoid and erratic behavior. There are multiple other witnesses who state similar observations and opinions. The Kentucky State Police investigation is Detective Stamper's investigation, giving the overwhelming evidence of Mr. Stein's mental state prior to and immediately following the shooting. Detective Stamper had no clear basis for testifying that Mr. Stines was in his sane mind. The Commonwealth is not required to put on exculpatory evidence or evidence demonstrating lack of criminal responsibility. However, the Commonwealth is not permitted to mislead and provide clearly false testimony when asked by the grand jury. Defendant seeks to unseal his mental health evaluation in part without specifically stating the contents because the report shows the investigation that was relied upon by the examiner is materially relevant to show the falseness of the testimony that nothing in the investigation showed defendant was not in his sane mind. Simply stated, the grand jury was very focused on the mental health of Mickey Stines, so much so that an unrecorded session was convened for only that purpose, to gather medical records related to his mental health. The prosecutor is not a gatekeeper. The grand jury is an independent body that sought information. It is not a coincidence that Detective Stamper's last statement to the grand jury was the response that his investigation revealed defendant was in his sane mind. This makes the distinction between a wooden stick and aluminum bat look trivial in comparison. The statement that the investigation did not reveal anything that would suggest defendant was not in his sane mind is not just a difference in opinion, it is false. Bluntly, there is not anything in the investigation that suggests otherwise, and Kentucky State Police agrees in their interviews. So regardless of what the investigation means to an expert, the question was whether anything in the investigation showed Mickey Stines was not in his sane mind. And the true answer is there are mountains of such evidence. It was up to the grand jury to decide what they would do with those mountains. The Commonwealth didn't have to go into the mental health at the charging juncture, but when the grand jury decided on their own they wanted to investigate this area, the Commonwealth is not free to mislead or lie to them. Let's jump on to Part B. The statement by Detective Stamper that the Ben Fields civil case was not related in any way is false and intentionally misleading and was prejudicial to defendant. Just a reminder, there was a civil case ongoing where an officer of Stines was being sued for having sexual relations with women that were on bail in the judge's chambers. During the proceedings, a grand juror asked about whether Judge Mullins had any relation to that case in any way. The prosecutor interjected and asked, "To your knowledge, was Judge Mullins involved?" To which Detective Stamper said, "To my knowledge, no involvement." First and most obviously, the Kentucky State Police investigation made it very clear that the events that were the subject of the civil suit, meaning the Ben Fields' improper sexual relationships with court participants, occurred in Judge Mullins' chambers. Secondly, the Kentucky State Police interviewed attorney and Mullins' close friend Daniel Dotson. The Kentucky State Police interview with Dotson reveals that Kevin Mullins had questioned Dotson about his legal involvement in the Fields case and why he had been to Prestonburg. In the same interview, Dotson ponders if Mullins was supplying information in the civil suit and suggests that Kentucky State Police talked to Ned Pillersdorf to determine if Mullins was supplying information because Mullins thought Mickey was trying to get him. Dotson goes on to note that Mickey's insurance-appointed attorney, Jonathan Shaw, get this, y'all, that one of the girls had a video of Kevin Mullins with someone bent over a desk. The Kentucky State Police asked specifically if they have the video in this case and clarifies the civil case, and Dotson says yes. The Kentucky State Police asked Dotson if, based upon his experience and knowledge, that Mickey's focus on Judge Mullins was singular related to this whatever imagined civil suit / criminal penalties, whatever he had in his mind, Dotson responded real and civil. Third, the Commonwealth was represented by the Attorney General during the recorded portion of the grand jury hearing. In 2022, the AG's investigators recorded an interview with Sabrina Atkins in relation to the case. She told the Attorney General that she witnessed a tape of Judge Mullins having sex with a woman in his chambers. She stated she knew Mullins and that his face was clear on the tape. This raises the question as to why the Attorney General prosecutor rephrased the actual question of the grand juror as opposed to not intervening in the in his sane mind portion. At the base level, she is charged with constructive knowledge of the Fields case and the interview of Atkins that explicitly connected Judge Mullins to the sex chamber events. The choice to not disclose this evidence when questioned by the grand juror is highly suspicious. The court chose to rephrase the question to allow the detective to state that there was no relation in any way between Judge Mullins and Fields' case in a knowing presentation of misleading testimony. Again, in comparison to the aluminum bat case, the misleading testimony in this grand jury is exponentially more prejudicial. The purpose of the grand jury requires that it remain free within constitutional and statutory limits to operate independently of either prosecuting attorney or judge. An abuse of the grand jury process poses an enormous risk to defendants. In theory, a trial provides a defendant with a full opportunity to contest charges against him or her. In practice, the issuance of an indictment oftentimes has a devastating personal and professional impact that a trial acquittal can never undo. The ex parte character of a grand jury proceeding makes it particularly important for the government to remember that the interest in a criminal prosecution is not that it shall win the case, but that justice shall be done. The grand jury is not solely an investigative body. It also serves as a protector of citizens against arbitrary and oppressive governmental action. Unrestrained misconduct in grand jury proceedings is inconsistent with the administration of justice in the courts and should be redressed in appropriate cases by the dismissal of indictments obtained by improper methods. The allegations of government misconduct in this case make it more vital that the Commonwealth presents accurate responses to the grand jurors' questions. Constitutionally, this body is to operate independently, and they sought answers to their questions about the mental health of the defendant and whether the Fields civil case was in any way related to the shooting. Nearly half of the 25-minute hearing centered on these issues. The defendant is entitled to a dismissal of the indictment based upon the evidence provided from the Commonwealth's investigation, as briefly stated herein. The court would then decide whether the violations result in dismissal with prejudice or whether the remedy is to grant dismissal without prejudice. And the Commonwealth represent this case to another grand jury minus the misleading and false testimony. Alternatively, to rule based on the motions, the defendant seeks an evidentiary hearing on these issues as set forth in Baker. And the last section, the defendant renews its motion regarding the unrecorded, unsworn testimony and incorporates its previous motion by reference. Defendant reiterates his position set forth in the motion to dismiss and incorporates the same by reference. Defendant will simply reiterate the importance of recording the testimony as set forth under criminal rules. Further, outside of legal advice and the deliberations, information given orally to the grand jury is testimonial, whether sworn or unsworn, and regardless of who is providing that information. It is evident there was a discussion of the case, else there was no basis for the grand jury's request. Finally, the defendant notes again that it is evident from the note, defendant has not been provided an actual subpoena to any entity other than Appalachian Regional Hospital what information was sought and was not provided. Wherefore, based upon the foregoing, defendant asks the indictment in this action be dismissed with prejudice. Alternatively, defendant asks this court for an evidentiary hearing on the matters presented above. So that is the filing. They do have the handwritten note by the jurors attached to this and then some transcripts from that grand jury proceeding. I mean, that is a big deal because that is going to be the crux of his defense is he had a break. And you see from people who knew him, they were concerned enough. They were actively looking to get him seen by his doctor. So I will keep an eye on this for you guys. If anything new comes up, I'll let you know. That is it for this episode. I hope you guys have a good rest of your Saturday, and we will see you soon.